yet?
Say again?
They should have sent over the certificate.
Huh? No, not Zoom. Zoom.
Mr. Nekrasov, I
Court
need you to
hearing, bro.
yourself if you're in a court hearing, sir. So I have the documents I have say that treatment has been completed, but we need to, it's the payment circumstances, I think, that are still being monitored, Mr. Downing, to let you know.
That was paid off, but I can contact them and get that squared away.
Yeah, if you could do that, I can certainly, even though I'm scheduling that hearing in February, we could certainly perhaps revisit that sooner. Address still work for you, Mr. Downing?
Yes, sir.
All right, we'll send it there. Thank you.
Thank you.
Are we in court?
All right, Mr. Nekrasov, if I could have you take yourself off and mute and turn your camera on, sir. Alexei Nekrasov.
Hello.
Hello. I need you to turn your camera on, sir, so I can see your face.
Give me 1 second, sir.
Okay.
Hold on. Where's the camera? It's right here. Hold on. Are you able to see me?
No, sir, I can't see you.
Hold on 1 second. Give me 1 second. Because I'm just installed this the Zoom app.
You have some sort of filter on your camera where you're a talking rabbit right now. So you need to, there we go. All right.
Hey, how's it going?
Can I have you state your name and date of birth?
I was born in 1988, February 1st.
Mr. Nekrasov, you're before the court because there was a warrant issued in December of 2021 for not doing 90 days of electronic home monitoring. I know you paid $100 to quash that warrant. The expectation is we need to get you signed up for those 90 days of home monitoring through 2Watch monitoring. Are you able to do that, sir?
We were trying to do it in back in 2001, I believe, September.
Yep.
Yeah, but we never had the. I mean, I'm installed this device, ankle bracelet, but seems like it was the wrong one. Make a call to the Washington State Patrol, and they said I got 2 warrants. I was kind of surprised because my attorney said we resolved it back in 2021.
I have a record of your court date, sir. I've listened to that record. You were sentenced to 90 days of home monitoring. You haven't done it, and because you haven't done it, there was a warrant issued 2 years ago. That shouldn't be surprising to you if you haven't done your sentence. So my question for you is, if I send another referral to 2Watch, will you get signed up for your 90 days of home monitoring? Just a yes or a no.
I'd like to say yes, but I'd like to see some other maybe conditions. Maybe we can set up something different if it's possible.
Either going to be home monitoring or jail, Mr. Nekrasov, at this point. It's been pending for too long. Okay. How many days in jail is going to be like? I'd convert the 90 days of home monitoring to 20 days in the Skamania County Jail, sir, if you want to do a jail sanction.
No, I'm just wondering,
I'm telling you right now what it would be.
Okay, so it makes sense to get this home monitoring, I guess. I have another question. So back in 2021, when I was trying to install this device, so we had the issue with that company. So
you're only doing it with 2Watch. They're the only state certified company. You don't get to choose your company. It's either 2Watch or jail.
Absolutely, sir. I mean, we can try one more time because I had the hard time back in the days, back in 2021, to install it. So
I'm going to schedule Mr. Nekrasov for you an in-person court date here in 2 weeks. Either you have gotten on the home monitoring at 2Watch within 2 weeks, or you're here in the Battleground Municipal Court in person for a court hearing. Do you understand?
2 weeks. Is it any specific date?
Yep. The court date in 2 weeks is going to be on the 11th of January, 2024.
Okay. So I'm going to put some note in my calendar. Thank you very much for your understanding, sir.
So again, I want to make sure you do understand. I'm going to send another referral to 2Watch for your 90 days of home monitoring. If you are on home monitoring and we have documentation of home monitoring, then I will cancel that court date on the 11th of January. If you are not on home monitoring on that date, you are here in Battleground Municipal Court at 1:30 on January 11th, 2024. Do you understand what the court is ordering you to do?
So I have to be in the court on January 11th, and I need to install the device.
That's not what I'm saying. I'm going to say it to you again. I'm going to send a new referral to 2Watch monitoring for you to begin 90 days of electronic home monitoring. If you begin that program before the 11th of January, you are not required to be in court that day. If I have documentation that shows you are on home monitoring, you will not have court.
I got it, sir.
I have you not on electronic home monitoring on January 11th, 2024. You need to be here in person.
Sounds good, sir.
Okay. We're going to be mailing you paperwork. Is your address still on 100?
Do you have any digital version of this letter?
Well, you've chosen to appear on Zoom rather than come to court. So I'm going to mail you that information. If you need me to say it again so you can write it down, I'm happy to do that. This is also being streamed on YouTube, so you can watch the YouTube broadcast for the next week if you need to get this information again. Do you want me to again state what the court is ordering you to do?
No, that's fine. The mailing should be okay.
Do you have any questions for me about what the court has ordered?
I have a lot of questions, but
No. Not playing that game. Do you have any questions for me about the specific thing that the court is ordering you to do?
Yeah, I have some questions about this to watch. You said the company name?
That's the only state certified company you can do electronic home monitoring with, and that's the company that your 90-day referral is being sent to.
Yeah, we had some issue with the company, you know, back in 2021. So that's why we never had this. That's why the device never been installed.
You have to follow their guidelines, sir. You either follow their guidelines or you're going to be doing jail time in Skamania County. Do you understand?
Absolutely, sir.
All right. Thank you very much, Mr. Nekrasov.
Thank you very much. Have a good day. Thank you.
You too.
Happy New Year. Thank you.
Christopher Olson present, and I believe Tiffany is.
I'm here.
Steinweg is there. Thank you. What I was looking for was an update on the mediation that was supposed to take place yesterday. What can the parties tell me?
What happened yesterday was we came to an agreement, not on a permanent basis, but temporary until December 31.
Okay.
And that would be he would get him every other weekend, but his mom would supervise.
Okay. Did you all want that to be a part of a temporary parenting plan, or are you both just asking for a bench order on that agreement through December 31st?
My concern is that the mediator said that if we do this and we don't come to court or have a final parenting plan in place, then it's going to go back to the original order, and I don't want to go there.
Okay, so I could give you two options. One, if the only thing needing to get done right now through December 31st is a change in that visitation to supervised visitation and specifics regarding when that occurs, I can do that in a bench order for you today, and then we could set up a follow-up review date to work on final orders. Or if you want to present me with a temporary parenting plan that you both sign and agree to, I could put you back on a docket next week or in 2 weeks, and I can sign off on that order. I don't know if you worked on a temporary order in mediation. I just don't have the document.
It was just verbal, and then she said ultimately you would make your decision today.
Okay. So, well, what I'm going to do today then is first, Ms. Steinweg, tell me the language that you two have agreed to. I'll ask Mr. Olson if he's in agreement to that. We'll put that in a bench order, and then we can certainly set another date. But I don't create the orders. You all create the orders and present them to me for review. So if you're wanting an actual final parenting plan, either we set that for trial, or if it's an agreed order, you all prepare that and present it to me.
Okay, so what about the show cause hearing that we discussed before? What is that?
We can get to that in a minute. Can you give me
Okay.
the language that you both have agreed to? And
Yes.
then Mr. Olson, I'll come to you.
So it would be every other weekend, Friday to Sunday from 6 p.m. to 6 p.m.
Friday to Sunday, okay.
And that would be a supervised visit at Chris's mom's
Okay,
house.
so it's at her home,
Yes,
and she must be present the entire time.
her or her husband.
Okay. And is Mr. Olson to be present the entire time?
No,
Okay, so he can come and go from that home during
Yeah.
visitation. Okay. Okay, anything else that was agreed to?
the other thing was for winter break. We split the break, so she would keep him. Kay would keep him from December 25th at noon till January 1 at 6 p.m.
6 p.m. And again, that would be with Kay.
Yes.
Okay. And that'll just be winter break for 2023.
Yeah.
Okay. Okay, so is there anything else?
No, just that he's not able to leave with him. It needs to be supervised.
All right, Mr. Olson, thank you for being here. Is that your agreement and understanding at this time regarding temporary visitation? Oh, you're muted, sir.
Sorry about that.
It's okay.
No, absolutely not. I don't know why I need to be supervised visits. I know that you did get the hair follicle back, and it went back to, well, I got clean on July 22nd. And that's when I got into treatment, and I've been ever since. And I provided with all my treatment UAs that I've taken at treatment. I've provided like what I have done up to this point, but like nobody's, I feel like, acknowledging that I took care of getting clean months ago. So I don't know. No, I absolutely do not agree to that. And every other weekend. So we're still back at ground zero, except for I've done quite a bit of stuff to better my life and my family's life, with the outpatient and with mental health, and I'm feeling pretty good, except for all this. So what now?
Can I
Okay.
say something?
Go ahead, and then I'm going to make my ruling.
So, okay, so yesterday we agreed to all this through the mediator. Is that not?
You guys,
Hey, Mr. Olson, no, thank you. This is her turn. I will come back to you. Go ahead,
Okay.
Ms.
He
Steinway.
even sent me an email, I didn't print it out, but stating that he was in agreement to that. So I don't understand. I don't. Let's just move forward.
Yep. Mr. Olson, what did you want to say?
nothing. You've already, go ahead and make your ruling.
Okay.
I don't know what to say. I did you not get like the paperwork I turned in or anything? Like,
What paperwork?
well, I dropped off from my,
API Community Observer, please mute. We're hearing you in the middle of another case. Go ahead, Mr. Olson. I apologize.
I turned in to the courts yesterday after the mediation
Mhm.
from my treatment facility, a letter from the head lady over there with a copy of all my UAs, and she explained that the Suboxone and the methadone that's on there, are prescribed, and then they switched them though, because one of them was giving me stomach problems, and so when you look at my UA, it says positive, but it's positive for my prescribed medication. And also I got a letter from my counselor from mental health.
Okay. So if you turned those things in yesterday, as you've been in this court enough to know, it wouldn't be available for my review today. It takes several days for it to get scanned into the system. You would have to leave a hard copy, bench copy, if you want me to see it 24 hours of filing. So I don't have that. What I do have today is a hair follicle test that is positive for things other than what would be prescribed medication. I assume that you have seen that as well, sir.
Yes.
Okay.
Do you know when that is from?
I have the date in front of me, date collected October 19, 2023.
And so that goes back to when I was using. But like I said, up until July is when I got clean. So I guess the hair follicle, I'm told, can go way back if the more money you spend on it.
Okay.
So I don't know.
Okay. Here's going to be my ruling today. With this recent October 19th, 2023 hair follicle testing, given the comments of the parties, I have no notes for mediation, but I think that the proposed language from Ms. Johnson is more than beneficial to you, Mr. Olson. Based on the hair follicle testing, I had revoked visitation until we got more documentation and information in. I think that the proposal from Ms. Johnson is very appropriate under the circumstances. I am going to issue that temporary bench order. I will get that issued today. It will specifically state that during visitation, your mother, Kay, is to be present at all times. You are not to take the child out of her home unless she is with you. So she or her husband need to be present for supervised visitation. I will set a review date so that we can review the documents you filed yesterday. The other outstanding issue was that Ms. Steinwig had filed a motion and order for default. I had initially denied that because Mr. Olson, you did appear. You did provide a declaration affidavit regarding your position regarding a final parenting plan. In this case, the problem I have is you haven't really filed a formal response. But I am going to find that it's enough to avoid a default order and move this case on to the merits. So I am going to deny the default. I am going to issue that bench order. Ms. Steinwig, what else are you asking for the court today before we set a review date? And I'll just let you know at this point then, since it sounds like mediation was not successful, your options would be to get onto our trial assignment docket and get this case scheduled for either a mandatory settlement conference or a trial.
I would definitely like to do the mandatory settlement conference. Because they scheduled us for another mediation, but if it's pointless if we're going to go in, agree, and then come back and it's going to be totally different the next day.
I would agree with that. So let's get you all, I'm going to issue this bench order. Let's set you for a trial assignment docket, which we have those every Wednesday at 1:00. At that time, you will be scheduled in front of a judge that is not me for a mandatory settlement conference. Probably, if I had a guess, it would be early next year, 2024. I doubt you'll have any December dates.
So, but this order will be current until we go to that, correct?
Yeah, and what I'm going to do is set a review date before December 31st on this docket with me, so that we can review how that new visitation is going.
Okay.
So what is the first, would you all be available? Well, is trial assignment open next Wednesday?
Yes.
Okay. Would you all be available next Wednesday at 1:00 to log on for trial assignment docket to get a mandatory settlement conference date?
Yes, I am.
Mr. Olson, are you available?
Yes.
Okay, so November 29, 2023 at 1:00. We'll get you scheduled for a mandatory settlement conference. Then let's get you a new date. Let's get you as close to the 31st. We could do December 27 at 9 a.m. back on this docket to review the visitation schedule. If for some reason you issues come up from either party, you are free to renote it back on this docket for review if you need to. But it would need 21 days notice to the other party. So December 27th is probably pretty close to where you'd end up anyway.
Okay.
Okay. Okay, I will get the bench order issued. Anything else from the parties today?
No, thank you.
Okay, Mr. Olson, any questions for the court?
Nope.
All right, thank you, sir. You're both free to log out. And Zachary Kiyoshi, I believe Ms. Fellows is present with us.
Yes, Your Honor.
Okay. I'm just going to get into my digital file here. So a question I have for the parties, I know we did change visitation at our last appearance. How is that going?
Who do you want to hear from first?
Ms. Vaughn, go ahead.
Okay, so the very first week of visits, I obviously had a lot of anxiety about him being with his father unsupervised for the first time, and he had provided a kind of vague itinerary, but at pickup or drop off, I should say, I asked him to specify locations, like places, rather than a park kind of thing. And he had said he would be at the park across from the Youth and Family Link building, which is Vandercook Park, or not Vandercook, Victoria Freeman Park, I believe. So when he was supposed to be there, I had called my sister who lives across the street and asked her to check outside to see if Corey was out there with his dad. And she said that no one was there. That proceeded for the entirety of the visit. He never showed up at that park like he was supposed to be at. When I picked my son up, I asked him what he did with daddy today, and he had said, "No, I don't want to tell you, mommy." My kid has never done that.
Okay, well, hold on,
after-
just a second. Hold on, ma'am, just real quick. Given the age of this child, we're walking into child hearsay. So I'm not
Yeah,
gonna accept it. You haven't, hold on. You haven't filed a declaration about any of this.
So I called back.
Well, hold on. I'm trying to help you out here. I'm not gonna hear what your child told you. That is child hearsay. I'm not taking that into account today.
Okay, he did tell me they went to a park, just not the one he was supposed to be at.
Okay. All right. Hold on, Ms. Vaughn. I'm going to come back to you. I'm going to tell you when it's your turn to talk again. Okay. I'm just going to be very specific. I did not put in my order that every second of the visit, he had to tell you exactly where he was. All I wrote was that he had to give you a proposed itinerary. So other than your concern that you don't know every second of every minute where the child is at, how is visitation going?
I can't tell you. Beth was supposed to be doing drop-ins, and as far as I'm aware, she has not done any. So I don't know.
Okay. Mr. Kiyoshi, how are visitations going from your perspective?
They're going good, Your Honor. It takes me an hour to drive down, so I try to get there early to maximize the use of the 2 hours, and then have them back before. I try to have them back before 1 o'clock. But other than that, visits are good. There's only so much to do, and the weather's getting cold and wet. So we've been doing a lot of things indoors, and there's not a whole lot of kid-friendly things to do indoors between 11 a.m. and 1 a.m. and 1 p.m. So I did talk to me and Beth Fellows had emailed each other about extending the time, and then me being able to take him out of Cowlitz County to be able to do more things because it is getting wet, and I can't take him to the park every time I see him because of the weather.
Ms. Vaughn, we had a hearing actually on this matter October 25th, and you weren't present. What happened?
I was never given notice that we had a hearing.
Well, Mr. Kiyoshi and Ms. Fellows were present, and it was in my order. And we actually set it at the September 27th hearing.
I was here that hearing then. I've never missed a hearing.
That's not what my notes show.
What day
Ms.
was it?
Fellows,
25th.
I'll tell you.
Ms. Fellows, what's your take on our current review of visitation and the changes we've made?
So at this point, by all accounts, it sounds like it's going well. I have not done a drop-in. I actually had planned on doing one last week, but didn't realize that Dad was on vacation, so there wasn't a visit last week. But it seems like it's going well, and his itinerary was a little bit vague, and so I did email him and ask him to be more specific, and he has since then. So I haven't had any issues with that. Regarding compliance and services, I did get a compliance letter from his DV treatment provider. It's dated November 7th, says that he is in compliance. He has completed his parenting program as well. So there's no issues about that. So at this point in time, I did email the dad. I did reach out to him last week asking what he thought would be logical and reasonable as a next step for visitation. And he did respond. And he gave me, a good response. He does want like an 8-hour visitation. He wants to be able to go to his home area of Olympia, and he really wants to take Corey home. But I'm not comfortable with that because I have not yet done a home visit. We weren't at that point where I needed to do that. So after emailing with him, emailing mom, thinking about where we are, trying to be very logical about the next step, I let both parties know in an email yesterday or last evening that I would like to increase the visitation to 6 hours, go from 11 a.m. to 5 p.m., that he can go out of Cowlitz County, but not to his home because I haven't done the home visit yet. The visit should remain only with him and his son.
because we're still working on the father-son relationship and bond. Continue doing the itinerary on Monday on Our Family Wizard, and that he transports. And I know that he really would like to have a meeting at the halfway point so he doesn't have to transport so far. But given that this is a day visit for 6 hours, I am still at the point where he should be fully responsible for the transportation.
Is a 6-hour day visit on a Tuesday something that Mr. Kiyoshi you can do with your work schedule?
Yes, I'm off all day Tuesday, so that would work. Like Ms. Beth Fellows was saying, I just was trying to see if we could meet halfway, so I'm not driving an hour. I leave an hour and a half early just in case traffic jams up because it is I-5. And then another thing we talked about was the father-son relationship. My only concern with that is we've done the supervised visits. I've turned in notes from the supervised visits, and it shows that me and my son have a good relationship. I don't understand why it still needs to be just me and him. I understand not bringing them home until the home visit is made by Miss Fellows, but the fact, like, I can't even take my son to go on the play date with his cousins at a park away from home. It's not going to be in this house, at a park away from home. I don't understand why I can't start introducing him to my side of the family. And they showed up to his birthday party, which was supervised by Parents' Place. He had a good time there. There were no issues. I don't understand where he's going to get overwhelmed by family is coming from. I get staying away from home. Why can't he meet his cousins at the park and play for an hour or two?
And Mr. Kiyoshi, you reside in Olympia?
Yes, ma'am.
Okay. All right. Ms. Vaughn, I am inclined to increase visitation to the 6 hours. I will talk about location. I am going to, at this time, decline for child to be taken to father's home, but will 6 hours from 11 a.m. to 5 p.m. work for the child's schedule?
It does interfere with his nap schedule, which he goes down between 4 and 5 p.m. So I had messaged Beth back saying 4, maybe 5 hours would be easier to manage with his routine than 6.
Mr. Kiyoshi, would 10 to 4 work for you?
I'm asking for 8 hours, and it keeps getting cut down.
Okay.
Yeah, I'm his father. Yes, I understand if he needs me.
I'm giving you, sir, we're increasing from supervised to 2 hours unsupervised to now 6 hours unsupervised. Yes, so I'm asking you first if 10 a.m. to 4 p.m. works.
Yes, yeah, that
okay.
Works.
So I am going to issue a bench order that increases unsupervised visitation from 10 a.m. to 4 p.m. on Tuesday. I will increase where he can go. So I'm not sure the timing really works out for him to be taken back to Thurston County. My preference would be that any indoor playtime, which it seems like that's the big concern for winter, certainly can be accomplished in Cowlitz, Clark, or Lewis counties, which are the adjoining counties to Cowlitz. So I think for right now, that is appropriate. It keeps child close to home. Then you're not driving an hour and a half back to Thurston. I'm not saying we don't get there eventually, especially after a home visit, but then this is at least a start, gives you more options for indoor play, especially in Clark County. I'm still going to have you provide the itinerary to Ms. Fellows and Ms. Vaughn. I will allow in public locations like indoor play areas and outdoor parks for cousins to be present for these visits. I do think that's appropriate at this time. I take into account that he's fully completed the parenting program and that he's in full compliance with his DV program at this time. Anything else, Ms. Fellows, that we need to address in a new order from your perspective until we meet again?
Not that I can think of. My understanding was that mom went in the morning on Tuesdays. So I just want to make sure that she's able to get Corey to the drop-off point in the mornings.
Are you able to get the child to the drop-off location by 10 a.m. on Tuesdays?
I do have therapy. I'm being treated for PTSD from 9 to 10 a.m. every Tuesday. So it will interfere with that.
PM or AM?
AM, 9 to 10 a.m.
Okay. Well, then I think we just have to go back to 11 to 5. I understand that that's going to probably interfere somewhat with a change in nap time, but I think that's just where we have to be at to balance the interests of Mr. Kiyoshi, child and mom. So we'll do the 11 a.m. to 5 p.m. on Tuesdays. Let's set a review date for this. How far out do the parties want to go?
I don't see a reason to change from this until he's completed his DV classes.
Well, my preference would be we set something after drop-in visitation has been done by Ms. Fellows and a home visit. So maybe I'll ask Ms. Fellows, should we be looking into January for a review date to get both of those things done?
Yes, that's what I would prefer.
Okay. And then in January, are we still, yeah, we'll still be at 9 a.m. on Wednesdays. Okay. What if we set this to January 17? So it gives parties about 2 months to get all of those things done. And I would, if the parties are going to argue for or against a change in this, it would be really helpful to have declarations or other materials rather than just coming to, so I can read those ahead of time, rather than just coming to court and telling me things that I don't have any documentation to support. Okay. Oh, okay. So January 17, 9 a.m. And it will, for Ms. Fellows, you may already know this, it'll be in front of Judge Evans starting in January.
Yes, Your Honor.
Okay, great.
So is the bench order that you're going to write, is it going to be about the adjoining counties? So Cowlitz and then adjoining Clark and Lewis?
Yes, I'm going to include that those visitations can include Cowlitz, Clark, and Lewis.
Okay.
Okay, anything else we need to do today?
So can anybody tell me what the hearing in October was supposed to be about? I have our bench order from September and it says our next review is November 22nd. So I have no clue what that was supposed to be for.
I have a review date in the bench order as October 25th, 2023.
Mine says
I
November.
believe, Your Honor, I think what had happened is you had set the review date for today, but when you wrote the bench order, you put in that October 25th date, I believe is what happened. And so I knew about it. Apparently the dad did, but the mom did not. I think it was mainly because in that September hearing, it was not announced that there was the October hearing.
Okay. So Ms. Vaughn, it wasn't a bench order. Mr. Kiyoshi was present. Ms. Fellows was present. We did note that you weren't present and we took no action and struck the matter and moved it to November 22nd today. So nothing was done, but there was a hearing.
Okay. And then the only other thing we had talked about the last hearing that didn't get brought up today was him getting my late father's mugs to me. He still has not done that.
Mr. Kiyoshi, I do remember talking about some of those personal belongings. Where are you at with that?
I can't find them, and I'm not, in all honesty, I'm not here for mugs. I'm here for my son. I don't know where her mugs are. She packed up, she moved out. I'm not going to be responsible for her mugs.
Okay, well, this is a petition for dissolution. As part of that, personal property is at issue. So we'll have to leave that as a contested issue for trial. And certainly Ms. Vaughn can make any requests about replacement value of those items if you have lost them. So I don't love your response, sir. It's a little bit off-putting, to be honest.
Yes,
You know, she does have the absolute right to ask about her personal property in a dissolution proceeding.
Yeah, I understand that.
So saying that you're not here for that is not okay.
Yes, Your Honor.
So we'll leave that as a contested issue when this matter goes to trial. Again, Ms. Vaughn, you'll be able to ask for those items. If they're not able to be found, you can ask for the value of them. And I understand there's some sentimental value there.
Yeah.
Okay. All right, thank you both. We'll see you back on January 17th.
Thank you, Your
Do
Honor.
I have Nancy Westleen and Denzel Westleen?
Yes, ma'am. You have me. Can you hear me?
Yes, we can hear you. Thank you.
Okay.
It looks like we were waiting maybe on signature of documents.
Yes, ma'am. It's a 401k that he had,
Mhm.
and LPL, they're not coming through with what they're supposed to do. So
So that has not been accomplished. Mr.
no, as far as I know.
Wesley, what can you tell me? My notes from last time indicate she needed to sign some documents and then the transfer could be completed. You're muted, Mr. Westling.
There we go. I just called my financial advisor, and he was trying to find out this morning some information to give you about what's going on. And as far as I can tell, we're waiting on signed documents from LPL and Nancy's financial advisor to send to Equitable. They're waiting for the initiation of this transfer of money, and the holdup right now is Nancy's financial advisor's been on vacation for the last 2 weeks, and so it'll be next Tuesday before I will be able to talk to somebody about getting that signature forwarded to Equitable.
Ms. Westling, does that sound correct to you, or do you dispute what Mr. Westling is
Kind of
saying?
in the dark. I thought we already did everything we supposed to do.
Hold on a second. Ms. Westling, I know you're on Zoom, but you are in a courtroom. You cannot be smoking
Okay,
during
sorry.
your court case.
Sorry. But yeah, as far as I knew, everything was ready. And it was a holdup with LPL, not my financial worker.
Have you talked to your financial advisor and signed paperwork to the best of your understanding?
As far as I know, yes, ma'am.
Okay. Well, it's hard for me to know without this got a he said, she said matter. I don't know. Mr. Westling, honestly, you've kind of been telling me the same story for a long, long time now. And what I dislike is when we give you a month to get something done, and then the day before the hearing, you're reaching out to your financial advisor to get a document to me for today. That doesn't help me. So I am going to give you guys another review date. Mr. Westling, this is a contempt motion against you. So you can't just sit back and wait for Ms. Westling or someone on her behalf to do something. You need to,
Your Honor.
Hold on a second, I'm not done. You need to proactively be the person to shuffle this through and get it done. This is on you. This is your account. So you have to get this done. If, as you're telling me, there's documentation that Ms. Westling needs to do something and isn't getting it done, then get me that documentation. But I find that hard to believe without any documentation in the file right now to suggest that. Go ahead, Mr. Westling. What do you want the court to know?
I just want the court to know that I have been proactive. I've called Equitable several times, and I don't know the number to LPL, but I have been trying to get a hold of her financial advisor. And as far as I know, they got the message that this paperwork needs to be filled out, but so far they haven't come through with it. I've been waiting. I don't have any money to live off of right now. My accounts froze up because of the whole thing. So I've been doing everything that I can to get to where I can make, have money to live off of.
So here's going to be my ruling today. So we've been here several times trying to get this done. The decree of dissolution incorporating this requirement was entered into on January 6th, 2023. So we're approaching a year. I find that unacceptable. We have got to get this done before the end of the year. I am going to set this out 30 days to December We'll have docket on the 20th. December 20th at 9 a.m. Does that sound right? Yes. Okay. We're going to set you to December 20th at 9 a.m. I want to know that this got done, but Mr. Westling, that gives you a little less than 30 days to really push this through. And if it's something that Ms. Westling still needs to do, then you or your financial advisor need to notify her or her financial advisor, because she's unaware of anything else that needs to be done to get this accomplished. So I'm giving that little bit of time for this to get done. But on December 20th, that'll be 11 months into this process. And I will consider sanctions at that time under the contempt motion if we don't either have it completed, or I have documents from financial advisors telling me we're getting real close, we've made substantial steps, or we're waiting on Ms. Wesling's signature. So if it's not done, I need one of those two things in my file before the 20th, okay?
Okay. One more thing, there was money coming from two accounts, one from Equitable and the other one from LPL.
Okay.
And the one from LPL, the smaller one, has been completed and was put into her account.
And I
So
think
it's
that
like
was
halfway there.
That was done previously, right? I think we had already.
No, it hadn't been. Just this week.
Oh, okay. Okay.
It went through.
And how much was that transfer?
It was I got a paper. It said 21,000 some change.
Okay. Ms. Westling, did you receive that amount in the last week or so?
I was told. I haven't went down and talked to my financial worker since we went down and signed a bunch of papers. So.
Okay.
And he also brought some over for me to sign so that he could get that other money.
Okay. That's all really positive news. I appreciate that, Mr. Westling. We'll see you back on December 20th, and hopefully we've put the last piece of the puzzle into place on this, and you all don't have to come back here in 2024. Okay.
That would be great.
Okay. Yeah. Thank you both.
Thank you.
Let's see. Do we have Mr. Reeves?
Right.
Okay. And who is Marlena that's turned on their camera?
I am Adeline's maternal aunt. Back in May of 2022, I started the emergency guardianship. And then May of this year, since Greg was doing everything he needed to do and was doing what he needed to do, I decided that to have her transition back to him. But I'm only here because Adeline, even before all this, since she was a month old, she's been staying with me weekly since she was a month old.
I'm gonna have you pause there for a minute. I'm gonna hear from the parties first, but I thank you for letting me know who you are and why you're here, and we'll come to you shortly, okay? Now, do we have Mr. Reeves present? Are you on the Samsung?
Yeah, he's trying to figure out his thing.
I just sent a request for you to unmute.
When court started, he was having some issues. It was showing just a screen that said the host will let you in soon.
Yeah, he probably was in the wrong courtroom. People log into the wrong docket that has not been started. Because if they log into this link, it puts them into our waiting room and notifies me. Can you send a message and let us know if you're still trying to unmute? I've sent you requests to unmute. Well, then you should, so he's responding to me saying it keeps telling him the host is not letting you unmute. And I'm just telling you, I'm sending you requests as the host asking you to unmute. I haven't blocked your ability to unmute. So you'll need to log out and log back in. We'll come back to your case. I'm going to call one case in while we wait for him to get reconnected. We have new contempt motions scheduled for December 6th that Mr. Kamba has filed, but what we're here on today is Desiree Kamba's motion for contempt dated November 1, stating that Ruben broke the no contact order by sending mail to my house. Ms. Kamba, is that what you're wanting to proceed on today?
Well, there was two in there. There was that one that he sent mail to my house, and then that he broke the no contact order on September 30th at the YMCA.
Okay. Have you served him those documents?
Yeah, they were all together.
She did not serve me, Your Honor.
Well,
I served him. The police did.
Okay, I don't see an affidavit of service of that motion. So when we were here on November 1st, we kind of had the same issue. But at that time, it was Mr. Kamba who had not served you. And so you were not here, Ms. Kamba, because you had not been served. So I struck the matter and asked him to renote it and file proof of service. Then on that same day, November 1, you filed a declaration and an order to show cause for today, but I have no proof of service, and I don't have any reason to believe that he's received it because I don't see a response. So again,
Your Honor, I did go into the courtroom and found that we had court today, and I paid to get the paperwork and everything, and I did file a response yesterday.
and she hasn't received that response, I assume.
No, and I paid the police to do my work.
Okay. Well, I'm just telling you, I don't have the proof of service, and he does have to be personally served with this. And I don't have any proof of that. So I am going to strike today's contempt hearing as well. You will have to renote it when you can provide proof of service to the court.
So I have a question real quick. Do you know how long it takes for the sheriff to give you back your papers?
It shouldn't take long, so I don't know. I would have no way to know that, except it should not be very long.
Okay, because I mean, I gave it to them like literally after I got your signature or whoever's signature, and I called them and they gave me two different responses. So I didn't know honestly if he received it or not, because I went there and they couldn't find my case. And then I called them later that day and they were like, oh, well, we're out doing it now. And I was like, okay. So I didn't know what was going on with it.
Okay. Well, and I'll just, so yes, I can't move forward on your motion today until I know that he's been personally served and have that in the file, proof in the file. Similarly, you all are set for December 6th right now on Mr. Kamba's motion for contempt against you. But similarly, I don't have proof of service of that motion. So I'm just giving the party a heads up that we're kind of in a position where you all are on my dockets almost weekly or every other week, but there's rarely, if ever, proof of service. So in every instance, I really encourage you to have that filed. Reach out to the sheriff's office, get the proof of service, file it with the clerk. You can help facilitate that if they have not filed it with us, okay?
Okay.
Mr. Kamba, anything else that you need the court to know today?
No, I haven't seen my son in over 2 months, and I'd like to see him effective immediately.
Okay, well, today I'm here on a motion for contempt. I'm not here on a motion to change visitation.
Well, so she took it upon herself to say that I was in contempt and just for existing in the same area when she showed up, and I left. So, I mean, this was already addressed to the court once, and I'm sure you remember that it was dissolved, and then now she's trying to bring it up again, and then on top of that, she's claiming that I served her paperwork.
And sir, all I can decide on are motions brought in front of me. There's nothing in front of me on this issue. Please file that, serve it on her, and make that request of the court. Okay?
She's avoiding being served, Your Honor, and you're well aware of this.
And then I'm not well aware of this. What I can tell you, Mr. Kamba, is that you can file proof of 2 attempts at personal service, and then we can talk about alternative service, such as mail, email, social media, text messages, etc. But you have not filed proof of any attempts at personal service.
Okay, and then my response that was filed today or yesterday, sorry, that has to be served to her as well.
It does. Anything that we don't do trial by surprise in Washington. Anything that you are filing with the clerk needs to also be served on the other party, always, in every case.
Okay.
Okay. All right. Well, we have you all back on December 6th, Mr. Kamba, on your motion for contempt. But again, right now I don't have that proof of service, so just giving the party a heads up on that.
Yeah.
Okay.
Is there a way that we could set a time for that? We can do an exchange of papers, not myself personally, but I have somebody, a server, and so she could stop avoiding being served.
I cannot coordinate proof of service. So you will have to work on that with Ms. Kamba or with the sheriff's office or with a process server.
Okay.
All right. Thank you both.
And also, in response to the contempt, like I said, I did file it yesterday.
I'm not hearing. I'm not going to hear any argument on the contempt. Sir, Mr. Kamba, hasn't been served on you. Your response hasn't been served on her, and you haven't served your contempt on her. So I am going to end the hearing today. You all are scheduled to be back on December 6th. Please make sure I have proof of service.
Okay.
Thank you both.
Thank you.
So when we were last here on October 25th together, we appointed Ms. Height. And I think this was just set on for kind of an initial review, essentially to make sure folks have been in contact with Ms. Height. So Ms. Height, let me just start with you. I know you were recently appointed, so I'm not expecting the world here, but just maybe a touch base on how things are getting started and if there's any guidance the court needs to be involved in.
Thank you, Your Honor. Started is probably too optimistic a word. I was appointed on the 1st. I sent out packets on the 2nd of November. And subsequent to that, I found out from Ms. Davenport that I had been given an incorrect address. I resent her packet on the 14th of this month. I have not received anything back, which is not surprising given that short time frame. Mr. Reeves' packet, which went out on the 1st, I've heard nothing back from. So I essentially have no information. My understanding from reading part of the file was that Mr. Reeves did not believe a GAL was necessary at this time. So I don't know if that's something that he was hoping to address today. That is literally the extent of my information today.
Okay. So I'm just looking to see, I think Mr. Reeves, since the last hearing, you had filed a request for reconsideration that kind of was in the form of a letter. So I'm not sure it really got logged in as such. So it sounds like you are stating you all have an agreement and you don't need a GAL. Is that what you are telling the court, sir? And then I'll come to you, Ms. Davenport.
Yeah, so basically I felt like there was just kind of some confusion. It might not have been listed under this case, but we had a GAL within less than a year. It was Mallory Smith, and I did submit the report. And I kind of just felt like this last case, we were ready to go to the 50-50, and then it came up about Marlene and her sister, and then that's when the whole GAL thing. I don't have problems with her sister and don't necessarily agree, but if it means the court can come to an end, then I have went into compliance with that. I mean, like I said, I don't think that Marlene is a bad person or anything, and I don't think it's bad there, but if it means court coming to an end because it's hurting my work, me financially, and all this stuff, I just want the 50-50. And then I kind of told Cassandra and her sister that they need to duke it out their problems. If there's like I know there's like grandfather or grandparents' rights. I don't know if there's like aunt rights or anything, but I don't feel like I should continue this court battle because of what they have against each other. I would just really like it to come to an end. I know that me and Cassandra have agreed on the 100%, maybe not necessarily the whole how she feels about her sister, but I really don't want to be a part of this and keep going to court. Like, my work's getting kind of upset with me. It's been going on for almost 2 years, and I just wanted to come to a close.
Ms. Davenport, what do you want the court to know?
Hi. that I am in compliance with the 50-50. I think Adeline is safe with Greg and I both. And there's no reason why she can't have equal time with both of her parents. And then with the whole Marlena thing, just a second. Sorry. I have to pause this. I'm sorry. My childcare went out of town for Thanksgiving. So
Oh, totally understood.
sorry. Yes, baby. Okay, I'm so sorry. Anyway, I know that Marlena is attached to Adeline, but I do have concerns. Like the doing dabs in front of my daughter. When she was going around Marlena and staying the night, I don't believe my sister's done anything like that to my daughter. But
Okay, so that's that's not what we're here for. So we're here for the first GAL review.
oh yeah,
I'm
with
hearing. Hold on, I'm hearing you and Mr. Reese telling me you don't want a GAL. I'm not reversing that decision. I am keeping Ms. Height on this case. I do feel like this court has to make a ruling on what's in the best interest of the child. And because I know that at some point a guardianship was filed for this child, I am not just going to take at face value from Ms. Davenport and Mr. Reeves what is in the best interest of the child. We do need someone else to meet with the parties, to investigate this, and to report back to the court. So that will include all parties involved. I'm keeping its height on the case. We will, I think we set review dates otherwise. And what I would say is, Mr. Reeves and Ms. Davenport, please, you've received paperwork. You probably will also get requests to talk with Ms. Height. Those are court mandated obligations that you have. So I do need both of you to participate in that.
Okay.
I think our interim report review date is January 10th, 2024 at 9 a.m. So that will, oh, go ahead.
I'm sorry, Your Honor. I was wondering if the January 10th date could be moved to either the 3rd or the 17th of January.
Absolutely.
I am unavailable on the 10th. I'm available both of those other dates. And then the final review, as you see there, is for mid-February. I'm hoping that could still stand.
Okay.
The mid-February date. I don't necessarily want to change that one.
Okay. Let's do January 17th. We'll strike January 10th and we'll change it to January 17th at 9 a.m. for the interim review. And then we'll keep the February date, but certainly we can revisit that on this January 17th if we need to, depending on how the investigation goes at that point.
What was the February date?
That.
Ms. Height, go ahead.
I just said thank you. I appreciate that change.
Okay, thank you. And then I think Mr. Reeves, you were asking a question. Go ahead.
Yeah. What was the February date again? Was it like the 13th or the?
Yeah, February 14.
14th. And then I had so I have been waiting for a phone call. I didn't know it was going to come in the form of mail. I will recheck through my mail. Is it like a big packet or is it like just a regular letter?
It's a packet that looks like this.
Okay, I will re-look through my mail, and then if I cannot find it in there, then I will reach out to you.
Okay.
All right. Sorry about that.
Okay. Anything else we need to do today?
Can I speak now, or were you waiting?
So I don't know that I need your input today unless there was something real urgent and pressing. What?
Well, Adeline has been, even after my guardianship went to Greg, she's been staying with me one night a week. And Greg, which I can provide proof of this, but Greg and his mother both told me that Cassandra was harassing Greg really bad, to the point because of Adeline staying the night with me. But she's been doing that since she was a month old. And her and I are extremely close. We have a very strong bond. And so now I am told that she can't stay one night. I was informed, this is how it was told to me, that if Adeline continues to stay one night a week with me, that they would reopen a case, and that Greg couldn't do that because of work and he just needed it to be closed, which confused me. And I was going to submit a statement, but I figured
yeah. So ma'am, you're not a party to the family law matter. So if there's information that you have regarding what's in the best interest of the child, please reach out to Ms. Height. That will be the avenue for that. I can't actually take testimony from a non-party right now, just orally.
Okay.
So, because I understand I understand there's no guardianship in place right now today, correct?
Yeah. No.
Right.
Because
So-
Greg stepped up and did what he needed to do. Me and the guardian ad litem at the time.
Understood. And that's why you wouldn't be a party to this family law case, even though you were a party to the guardianship case. That case has ended. But your input is valuable to Ms. Height. Please reach out to her. And then that information can come when we meet back on January 17th. But it is true, without a guardianship in place, you don't have legal standing over the child sitting here today. So you yourself can't mandate, visitation. If a parent chooses something different, that's certainly their prerogative at this time. My last notes show Ms. Davenport and Mr. Reeves stating that 50-50 was going well informally. And right now that's what's in place.
Yeah, and no, I'm not here for any visitation. I just wanted to kind of figure out what was actually going on in the case because
okay, and again, I'm gonna go ahead and end the hearing on this matter again because you're not a party. I can't give you legal advice. I mean, okay, you're welcome to participate. I mean, you're not participate. You're welcome to watch these proceedings. But since you're not a party, there's really no kind of request you can make of the court in this case. But again, reach out to Ms. Height if you want to give some input.
Okay, yeah, I have, yeah, okay.
Ms. Height, go ahead.
Thank you. Your Honor, my general system is that once I've received my intake packets and reviewed those, I set up visits with the child and the parents, and I do not typically contact collaterals until after that time. So it would be some time before I would have any information from Ms. Marlena. And with that in mind, I wonder if you could encourage the parties to return their packets as soon as possible. That would certainly help me move this forward.
Yes. I think that's completely realistic. And I think we did discuss that. Mr. Reeves and Ms. Davenport, go ahead and make sure you return those packets as soon as possible. I think we've done all we need to do today. I'm going to go ahead and end this hearing. Okay.
Thank you. Thank you, Your Honor.
Most predominantly, and the
Thank
rest of the other motions kind of flow from it, is Mr. Jackson's motion to vacate a prior judgment. When we were here last, we continued this case to today because Mr. Jackson was seeking counsel, or new counsel, I should say. So, Mr. Jackson, can you let the court know, and I don't have cameras turned on for either one of you. Can you let the court know where you're at? I don't see notice of representation at this time.
I have not gotten any counsel. Everybody I've talked to will not work in Cowlitz County. So I'm still seeking counsel.
Do you have any appointments set up, or?
No, ma'am. Like I said, everybody I've talked to will not work in Cowlitz County.
Okay. So what is your request of the court today?
Continue.
You're asking for another continuance? Is that correct?
Yes,
or are you asking to proceed on your motion to vacate today?
Let's proceed with the motion to vacate.
Okay. Ms. Jackson, are you ready to proceed on the motion to vacate?
Yes, I am, Your Honor.
Okay. So that is the first issue we're going to take up. I do note that there was the initial motion filed. There was an October 18, 2023 response filed by Annette Jackson to the motion to vacate. And then I have also received an October 31st declaration from Tanya Quinada. I have received an October 31 declaration from a Christopher Pangilinan, if I'm pronouncing that correctly. I've received and reviewed the October 20th declaration of Mr. Jackson that does also relate to his motion to vacate, as well as response to some of the potential contempt motion that Ms. Jackson has filed. What I don't see is whether that November 20th declaration of Mr. Jackson was filed on Ms. Jackson.
Yes, it was, Your Honor.
So I received in the middle of the night 2 emails. One was at 11:43 p.m. on Monday night, which was the 20th, and one was exactly at midnight on the 21st, so yesterday. I have truly, honestly, no clue which one I'm going by, because the declaration, the writing part is the same, just not the evidence.
I'm sorry, I didn't quite understand the last part you said.
Sorry. The writing is the same of both of those, and just not the evidence. It's 2 different things that I have, the exhibits. So I'm not sure which one he would like to go by, especially beside me, it got served me in the middle of the night. So it was, yesterday morning.
Yeah, so I mean, I guess that's my question. This case has drug on for quite some time.
Yes.
My issue, though, is that Mr. Jackson appears to be filing some additional evidence regarding, I think we can still move forward on the motion to vacate, because I think all of that evidence has been properly served and everyone's had a chance to respond. But it looks like he's making some arguments with regard to your motions for contempt that I'm guessing you want to respond to.
Well, I would like to know which ones he wants to vacate now.
Yeah, so that's not my question. My question is whether so you have very recently received this paperwork, which really isn't timely. All documents need to be filed on other parties with sufficient time to respond to a hearing, and typically that's at least 5 days before the hearing. These were filed 2 days ago with the court. You received them, it sounds like, last night. Are you planning to respond to the documents that he has filed on you?
You mean by writing or just by now at the hearing?
Either one.
I mean, I can respond to it right now as I'm talking,
Have you had enough time to review his November 20th declaration?
Yes, I did.
Okay. I mean, typically, I would say filing something on someone by email, which also is not sufficient, at midnight is not sufficient. So, Ms. Jackson, if you wanted time to respond and prepare for a hearing on it, you certainly can. It sounds like you want to move forward today. Is that correct?
Well, so, Your Honor, we have been doing this for months now,
yes,
and they will always do stuff in the last minute to drag it out. The whole, when I say they know who they are. And it's just like I get this declaration of Christopher Penguin and of Tanya, and this never got served to me. So, I saw it and I had to drive up to Longview, pull it, it's like they are doing certain things. So that's frivolent. What they are doing to me is doing everything last minute. So we are pushing this out and out and out. We all know he's not going to get an attorney again. This is, because his other attorney had filed when he quit with an RCA 16A and B.
So, hold on, Ms. Jackson. I'm just limited question here. Are you asking for more time given the untimely and improper service made on you, or are you asking to just move forward and you're ready to respond?
I'm moving forward. I'm over it.
Okay. All right, Mr. Jackson, we're first going to go to your motion to vacate. As I understand it, and looking at your motion, at the time temporary family law orders were issued in this case, you were represented by an attorney of your choosing. And what you are arguing at this time is that this court should vacate the temporary law orders. You've argued ineffective assistance of counsel, breach of professional ethics, and other duties, primarily, all related to what you believe to be actions or non-action by your prior attorney. Is that correct?
That is correct.
Okay, so I'm going to turn it over to you for argument on why you believe this court can and should vacate those temporary orders. Go ahead.
I had no knowledge of 2 of the cases that went to court. I'm I found out that there was 4 times they went to court. I had no knowledge, and I was not represented, and I was not there. Not sure if the attorney knew about it because he wasn't there either. So I didn't get served any paperwork saying I had court or anything. So that's where I'm standing.
Okay. Ms. Jackson, briefly, I'm going to hear from you just on the motion to vacate. I don't want you to get into the contempt or discovery issues right now.
Yeah.
Go ahead.
He got served each time his attorney got served. He got served. I even reached out by text message, letting him be aware that, hey, there's a hearing. I also asked him at one point, does your attorney still works for you? And he's like, why? So I explained to him why. And I mean, truly, honestly, I have to say, if I have an attorney, I'll reach out on a regular basis and to see where are we standing. And if the attorney doesn't respond, maybe I should get a little bit more aggressive. I don't know. And the motions that he's trying to vacate, they're overridden already. They don't even exist no more from July and August because Judge Evans wrote a new order for September 12th. So there's my 2 cents.
All right. So what I'm going to do is kind of go through a history of this case from early on. This petition for dissolution was filed on June 7, 2023. Ms. Jackson filed a notice of appearance pro se on June 7, 2023. Mr. Jackson had an attorney notice of appearance filed on June 26, 2023 by an Ivan Culbertson, private retained attorney on behalf of Mr. Jackson. A response to the petition for dissolution was filed that same day. Motions for temporary family law orders were actually filed by Mr. Culbertson on behalf of Mr. Jackson. Financial declarations were provided that same day. It was noted for motion docket on July 18, 2023 by Attorney Culbertson. On July 12th, you all were seen on this unrepresented docket. Mr. Culbertson appeared. Because Mr. Culbertson was representing the parties, the case was moved to the represented docket. Then on July 18, 2023, in front of a judicial officer warning, the case was heard. Ms. Jackson was present. Mr. Culbertson, the attorney, was present. Argument was taken regarding the temporary orders. The court made rulings regarding the temporary orders on that date with Mr. Culbertson present. Those orders were signed on July 8, 2023 by the judicial officer. So now kind of what's happened since is Ms. Jackson has asserted that Mr. Jackson has not adhered to the temporary orders, and she filed contempt and show cause matters with proof of mailing to Mr. Culbertson. I'm just looking for his intent to withdraw. So then through this process, on September 12th, well, let me back up to a September 5, 2023. This is a motion that Ms. Jackson filed for contempt with an affidavit of service on Mr. Jackson. A motion hearing was had in front of Judge Evans on September 12, 2023. At that time, Judge Evans took testimony from Ms. Jackson regarding service. The court responded that at the last hearing, they had discussed service issues and Mr. Jackson had been personally served. Ms. Jackson had also served Mr. Jackson via email and mail because of a lack of response from Mr. Culbertson since the time of the temporary orders. The court reviewed the Washington State Bar Association website to verify the address for Mr. Culbertson. The address of service did match. Mr. Jackson was present, or excuse me, Ms. Jackson was present and indicated she had not received any response or correspondence from Mr. Culbertson. The court then issued a ruling that granted Ms. Jackson's request to increase spousal support, provide housing assistance, and other orders within the September 12th motion hearing. At that time, Judge Evans did find that service was acceptable. There also, at that time, well, strike that. Let me back up. On September 25th, 2023, this court received Mr. Culbertson's notice of intent to withdraw. Then we end up here because Ms. Jackson has continued to assert that Mr. Jackson has not complied with the temporary orders. And Mr. Jackson now has raised the ineffective assistance of counsel arguments to the court. My finding is that motions to vacate are appropriate where, for instance, there is an irregularity in the proceedings or some other fault can be found in the process, how these orders happened. That is not the case here. This is a case where Mr. Jackson's remedy lies with any action he has with his attorney. This was a private retained attorney, his ineffective assistance of counsel, and I'm not making that finding, but I'm stating the argument that there was ineffective assistance of counsel is not a grounds for this court to vacate a properly ordered temporary family law order. Similarly, the other grounds regarding any breach of ethics by Attorney Culbertson similarly are not grounds to vacate. A client will be held to the orders that their attorney was properly notified about, was present for, or had the opportunity to be present for. So I am at this time denying the motion to vacate.
Thank you, Your Honor.
So let's talk about the other two motions we have in front of us. One is a motion hearing to restrict abusive litigation. And I believe, Ms. Jackson, that's what you have filed.
Yeah.
Okay. And then a motion hearing regarding contempt issues. Here's this, I'm going to short circuit this a little bit. Just based on the pleadings, I don't find that there's enough for me to make any sort of ruling regarding abusive litigation. I have denied Mr. Jackson's motion to vacate the prior judgments, so I think it's appropriate to move forward on the contempt issues. But hold on a second, but I am not finding, as far as Ms. Jackson's motion to restrict abusive litigation, that there's any merit. Mr. Jackson, go ahead.
I was the one that filed for abusive litigation as well.
Oh, yeah.
Well, I think there's two. Well, it's showing up as one, but you both have made that request in your motions. So
I never received anything from her.
Well, I was just looking at it. It's in a document. Yours was filed on October 11th, and then her request is, just a minute, I will get there, on October 18th, 2023. Unless I have mistaken, did Ms. Jackson, did you not intend to file your own motion to restrict abusive litigation?
You know what, Your Honor, I really don't know at this point because there's so many paperwork that I truly honestly, I do not know anymore. I was trying to move with my daughter in, it's been like, paperwork. So I truly honestly do not know at this point if I filed for it, probably because, I mean, all the stuff that they're saying that I have, overdone on paperwork, which
Mhm.
I just think I just filed everything as supposed to.
Okay, so I guess let's make the record clear then. I took your October 18th, 2023 request to be a motion to restrict abusive litigation. Sounds like you're not making that motion to the court, so we can strike that.
Yeah, let's just strike it. I'm just like, yeah.
Okay, and then let's go back to Mr. Jackson's motion to restrict abusive litigation. I do have that motion in front of me. My understanding when I read that motion is essentially kind of the basis appears to be the multiple contempt motions.
Yeah.
That is correct.
Okay, so Mr. Jackson, I'll hear briefly on that matter if you want to add anything to the record.
I want to add something about the earlier judgment is I was not the September 12th hearing. I knew nothing about, had no paperwork on it. And
But
said I was served.
I'm not going to revisit my ruling on that. You were on September 12th, you were represented still by Mr. Culbertson. He should have appeared on your behalf. So I'm not revisiting my decision on the motion to vacate. I'm hearing now your motion to restrict abusive litigation.
Okay, well, it's contempt after contempt after contempt, and most of it is just flat out lies. I've done, especially the 18th of July order. I followed the rules right there from the beginning. As soon as I got them. And then the 12th, I knew nothing about until I was sidelined when I was in the hospital. So we exchanged cars. I have no idea what money I'm supposed to put in the bank because I don't have any money.
Do you have the September 12th order now?
No, I do not. I've been looking for it. I don't have it.
They got personally served to him. They got served to him by, because I had first the sheriff's office in the courthouse. I wanted to have him.
Hold on. I'm just going to address something that's happening in the Zoom chat. So for non-parties to this case, I'm not taking testimony from non-parties. You're welcome to be here observing. Please do not use the chat to talk about the merits of the case. I see that is happening for Ms. Quinata. I'm going to delete those messages. They are not part of the court record. Ms. Quinata is not a party to this case. She has filed a declaration, and that will be considered by the court. But the statements made on Zoom will not be considered by the court. Please refrain from doing so. Okay, go ahead, Ms. Jackson.
No, he was talking. Wasn't he talking? I'm sorry.
Oh, Mr. Jackson, go ahead.
Yeah.
I apologize.
No, it's fine.
No, I was just saying, I don't have any of those from the 12th of September or whatever it was. I don't have those papers. I've been looking for them. And I'm not sure what they even look like.
So Ms. Quinata keeps replying to me regarding this case. Please refrain from doing so. Otherwise, I will remove you from the Zoom hearing room. Please do not use the Zoom chat while we're in the middle of a hearing. Okay, Mr. Jackson, please go ahead. I apologize for having to interrupt you again.
So I have none of those. Again, I was sidelined when I was in the hospital about this order that I'm supposed to be following, and then I was in contempt of. I still do not fully know what it entails.
Okay. So you still don't have the September 12th order?
No, I've looked through every paper I've got.
Okay.
Which I have a lot, which doesn't even, I don't know.
Okay. Are you able to come to the Cowlitz County Superior Courthouse and get a copy of that order?
Yes, I will.
Okay. Here's what I'm going to do. On the motion to, hold on, Ms. Jackson, is that you?
Yes.
Okay, go ahead.
So I had on the 12th, when the orders got down by Judge Evans, I went down to the sheriff's department, filed there for it to get it served to him directly, paid my dues, everything. After 2 weeks, they still have not been filed with him. They had not been served with him. So I withdrew those, and I had somebody serving him that Saturday, which was, I think, if we look in the paper, was on 9/28.
Okay.
At 8:30 in the morning, he was served, and he opened the door, and he got handed by Andrew, and yeah, Brad Shawnsbury. I do not know his name right now, but yeah, he got served, and he was getting the papers, and everything is filed in the records that he got them.
So here's going to be my ruling. First, on the motion to restrict abusive litigation filed by Mr. Jackson, I am going to deny that motion. I don't find that the contempt motions are abusive litigation. But on those contempt motions, I do not believe under the circumstances that I can find that his failure to comply was willful, which would be required for me to find contempt. So I am denying Ms. Jackson's motion for contempt against Mr. Jackson. What I am going to do in this case, because I do understand that Mr. Jackson, number one, believes that his attorney was not giving him documents, and I don't think that's a reason to vacate, but I do think that's a reason to find that his actions in failing to comply were not willful. So I am going to request that Mr. Jackson come to the Cowlitz County Courthouse and receive a copy of the September 12th, 2023 order. I am going to ask Mr. Jackson, well, not ask, I'm going to let Mr. Jackson know that because I'm not vacating those judgments, you will be expected to comply with them moving forward. So please, I understand tomorrow's a holiday. Friday, the courthouse is closed. So please, by next Friday, so sometime next week, come and get a copy of that order. Make sure you understand it and you're in full compliance of it, because if Ms. Jackson were to bring a contempt motion down the road, I wouldn't necessarily be able to find the same finding that I'm making today. So I'm giving you time to receive, review, and comply with the September 12th, 2023 order before I would deem any non-compliance willful. Mr. Jackson, do you understand my ruling?
I understand.
Okay. Do you believe that you could get to the courthouse and receive that order by the end of next week?
Yes, I can.
Okay. Ms. Jackson, do you understand my ruling today?
So yeah, so he has to pick up the paperwork. So is the ruling of Judge Evans, what's it called in English?
Both Judge Warning and Judge Evans' prior rulings remain in place. They are not voided. They're not vacated. They are the law of the land in this case. All I'm doing today is saying up through today's date, I am not finding contempt on behalf of Mr. Jackson with regard to your most recent contempt motions. I'm giving him time, now that I've ruled on his motion to vacate, I'm giving him time to receive the order, review it, and be in compliance.
So if he picks it up by next week, Friday, from there on out, he has to move out. He has to do all of this stuff that Judge Evans had written down as an order, right?
Well, I want to be careful here, Ms. Jackson. I understand that I assume that there might be a no contact order still in place.
It's still in place, Your Honor.
That would take precedent over this. So no, I think you're mischaracterizing my ruling, Ms. Jackson. So let me be very clear.
Okay.
You still absolutely must abide by a no contact order, and I don't want there to be any confusion about that.
Okay.
That is based on a totally separate cause of action that has nothing to do with a family law case. So a domestic violence no contact order has to be complied with. Failure to comply with that can result in criminal charges. So that is in no way my ruling.
Okay, but so I'm a little bit.
Hold on.
Yeah.
So I'm not going to dive deeper into the back and forth on whether you think that the no contact order is valid or not. So let me just ask very, very succinctly, do you have any questions about my rulings today that you need clarified? Not about legal advice about the house or anything like that.
Yeah, I mean, I do not understand the no contact order. I don't have contact to him. And
again, I'm not discussing the no contact order. I'm asking if you have questions about my rulings today, which deny the motion to vacate, deny the restrict abusive litigation motion, and deny the contempt issues. Do you have questions about those matters?
yeah, but it's right now it's like English is my second language. So some of that stuff sometimes just is like really hard on me to understand any of that. So I don't know what to tell you. I'm like really confused right now.
Okay. Mr. Jackson, do you have any questions for me about my rulings today?
No, ma'am.
Okay.
Do I? Well, I do, yes.
Okay.
So after I get this order and I go over it, do I have the ability to contest this order?
So either party always, before finality of a dissolution proceeding, can make motions to modify orders for good cause. So the short answer is yes, but the long answer would be yes, but it depends on the facts that you would present to me.
Okay.
Okay.
Thank you.
Okay, I'm going to go ahead and end the hearings. Thank you both.
So are we having then setting up a next appointment right away or not?
I am not, there's no further issue in front of me. So it would be incumbent upon the parties to renote if they want to bring a new issue to this court.
So the orders that he's picking up, I mean, are they working or not? Are they going to be good or not? I'm like really confused right now. Like,
so then if
he has to follow the
Ms. Jackson,
yes.
So I can't give parties legal advice, just like Mr. Jackson. You know, I can't throw him a lifeline either. I can't throw you a lifeline. I can only make a decision based on what's in front of me. So if you are having difficulty understanding proceedings, and I get it, it is difficult to navigate legal proceedings without lawyers. Certainly reach out to legal aid clinics or a lawyer if you want further clarification. All I can do is tell you that the temporary family law orders that prior judicial officers in this case have put into place remain in effect. Mr. Jackson is bound by those absent a motion and ruling to the contrary. At this point, I am not setting a review date because there's nothing else for me to decide unless the parties bring a new motion and note it for docket. Okay.
Okay.
All right. Thank you both. And we will go ahead and end docket.
All right. Thank you.
Thank you.
Thank you.